Good day. So this is Almadin John Mark from Section D. This is my final examination in CLJ400. So number 1, define evidence and explain its scope. So evidence is the means sanctioned by these rules of ascertaining in a judicial proceeding the truth respecting a matter of fact. This scope, the rules of evidence shall be the same in all courts as otherwise provided by law or these rules. What are the 3 kinds of evidence? Briefly explain each. So, object as evidence. Object as evidence are those addressed to the sense of the court. When an object is relevant to the fact in issue, it may be exhibited to examine or viewed by the court. While documentary evidence is the documents as evidence consists of writings, recordings, photographs, or any material containing letters, words, sounds. Testimony confined to personal knowledge. Witness can testify only to those facts which he or she knows of his or her personal knowledge. Distinguish corroborative evidence from cumulative evidence. So, corroborative evidence is additional evidence of a different kind of and character that tending to prove the same point. It is a piece of evidence that may be derived from various sources but proves a common point. Meanwhile, cumulative evidence is additional evidence of the same kind and character tending to prove the same point. What is prima facie evidence? Prima facie evidence is evidence which, if unexplained or uncontradicted, is sufficient to sustain a judgment in favor of the issue it supports. What is dying declaration? So under section 37, dying declaration, the declaration of a dying person made under the consciousness of an impending death may be received in any case wherein his death is subject of inquiry as evidence of the cause of surrounding circumstances of such death. What is statements authored as part of the res gestae? Section 44, part of res gestae, statements made by a person while a startling occurrence is taking place or immediately prior or subsequent thereof under the stress of excitement caused by the occurrence with respect to the circumstances thereof may be given in evidence as part of res gestae. What is the order of examination of individual witnesses? Briefly define each. Revised Rules of Evidence, Rule 132, Section 4, order in the examination of an individual witnesses. The order in which the individual witness may be examined is as follows. A. Direct examination by the proponent. B. Cross-examination by the opponent. C. Redirect examination by the proponent. And D. Recross examination by the opponent. Briefly explain what is judicial affidavit. The judicial affidavit rule took effect on January 1, 2013. A normal court proceeding will take around 3 to 5 or even more years to be fully decided. By requiring the submission of written affidavits of witness through the GAR, the time for concluding a court proceeding will be shortened. An offer of compromise in criminal cases is an implied admission of guilt. What are the 2 exemptions? Number 1, in quasi-offenses or acts defined and penalized under Article 365 of the Revised Penal Code, reckless imprudence and simple imprudence or negligence, and 2, those allowed by law to be compromised. Their usual examples are found in the Revised Penal Code, particularly Article 266, letter D of the Revised Penal Code. In order for evidence to be admissible, it must be relevant and competent. When evidence relevant, when evidence competent. Relevance, when evidence is relevant if it has a relation to the fact in issue as to induce belief in its existence or non-existence. From this rule, we gather that there are 2 components of relevance. First, relevant evidence has a relation to the fact in issue. Competence, in addition to relevance, admissible evidence must also be competent. Under Rule 128, Section 3, evidence is competent if it is not excluded by the law or these rules. If a piece of evidence is disqualified by the law or the rules of court, that is not competent and will be inadmissible. What is leading questions? When is it allowed? Section 10, leading and misleading questions. A question which suggests to the witness the answer which the examining party desires is a leading question. It is not allowed except on cross-examination, on preliminary matters, and when there is difficult in getting redirect and intelligible answers from a witness who is ignorant, a child of tender years, is of feeble mind, or deaf mute. D. Of an unwilling or hostile witness, or E. Of a witness who is an adverse party or an officer, director, or managed agent of a public or a private corporation, or of a partnership or association which is an adverse party. What is misleading question? A misleading question is one which assumes as true a fact not yet testified to by the witness, or contrary to that which he or she has previously stated. It is not allowed. When is circumstantial evidence sufficient to sustain a conviction? Section 4. Circumstantial evidence. When sufficient. Circumstantial evidence is sufficient for conviction if A. There is more than one circumstance, B. The facts from which the interference are derived are proven, and C. The combination of all circumstances is such as to produce a conviction beyond reasonable doubt. Distinguish burden of proof from burden of evidence. Burden of proof and burden of evidence. Burden of proof is the duty of a party to present evidence on the facts in issue necessary to establish his or her claim or defense by the amount of evidence required by law. While burden of evidence is the duty of a party to present evidence sufficient to establish or rebut a fact in issue to establish a prima facie case. What is standard of proof necessary in civil cases? Preponderance of evidence. How determined? In civil cases, the party having the burden of proof must establish his or her case by a preponderance of evidence. In criminal cases, proof beyond reasonable doubt. In a criminal case, the accused is entitled to an acquittal unless his or her guilt is shown beyond reasonable doubt. Administrative cases. Briefly define each. Substantial evidence in cases filed before administrative or quasi-judicial bodies. A fact may be deemed established if it's supported by substantial evidence or that amount of relevant evidence which a reasonable mind might accept as adequate to justify a conclusion. Substantial evidence is the least quantum of proof required by the rules. It is applicable in administrative actions, which, unlike judicial actions, do not include conducting full-blown trials and are meant to be concluded with greater speed. Define what are public documents. A. The written official acts or records of the sovereign authority, official bodies, and tribunals and public officers, whether of the Philippines or of foreign country. B. Documents acknowledged before a notary public except last wills and testaments. C. Documents that are considered public documents under treaties and conventions which are enforced between the Philippines and the country of source. And D. Public records kept in the Philippines of private documents required by law to be entered therein. All other writings are private. How do you prove and present in court private documents? Proof of private documents, due execution, and authenticity must be proved by any of the following means. A. By anyone who saw the document executed or written. B. By evidence of the genuineness of the signature or handwriting of the maker. Or C. By other evidence showing its due execution and authenticity. The original document rule states that when presenting a document as evidence, only the original is admissible. What are the four exemptions? Section 3. Original document must be produced. Exemptions. A. When the original has been lost or destroyed or cannot be produced in court without bad faith on the part of the offerer. B. When the original is in the custody or under the control of the party against whom the evidence is offered and the latter fails to produce it after reasonable notice. C. When the original consists of numerous accounts or other documents which cannot be examined in court without great loss of time and fact so to be established from them is only the general result of the whole. And D. When the original is a public record in the custody of a public officer or is recorded in a public office. Who become a witness? Section 20. Witnesses. Their qualifications. All persons who can perceive and perceiving can make their known perception to others may be known to witness. When is an extrajudicial confession sufficient to sustain a conviction? Section 3. Extrajudicial confession not sufficient ground for conviction unless corroborated by evidence of corpus delicti.